Assalamu alaikum and a very good day to everyone who's watching. My name is Afi Izhan Shafi bin Imran Hadzali and my metric number is 056990. So today, my friends and I would like to talk about resulting trust. So resulting trust is an arrangement whereby one person holds property for the benefit of another, which is implied by a court in certain cases where a person transfers property to another and gives him or her legal title to it, but does not intend him or her to have an equitable or beneficial interest in the property. There are two situations of resulting trust, referring to the case of West Dutchlands Bank Kieran Zettrell against Arlington London Borough Council. Lord Brown Wilkinson identified two circumstances in which a resulting trust will arise. The first circumstance is where A makes a voluntary payment to B or pays for the purchase of property which is vested either in B alone or in the joint names of A and B. There is presumption that A did not intend to make a gift to B, as in the money or property is held on a trust for A, or in the case of a joint property by A and B in shares proportionate to their contribution. The second circumstance is where A transfers property to B on express trust, but the trust declared do not exhaust the whole beneficial trust. Both types of resulting trust are traditionally regarded as examples of trust giving effect to the common intention of the parties. Next, I will explain about automatic resulting trust. An automatic resulting trust will arise where the settler transfers property to the intended trustee, but the trust has failed for some reason. The trustee holds legal title of the property on trust. The beneficial or equitable ownership is retained by the settler. There are three situations to explain further on automatic resulting trust, and the first one is the failure of express trust. There is a failure to comply with one of the three certainties: intention, property, beneficial interest, or subject matter, and those are technical reasons, public policy reasons, and no declaration of trust. The next one is an incomplete disposal of beneficial interest. There is a failure to dispose of the entire beneficial interest. It is also known as resulting trust of surplus fund. And the last one is other reasons, which unskillful draftsmanship or draft of the trust deeds was not properly made and failure to anticipate further events. The presentation will be passed to another member.
My name is Anwar Lukman Hakim Yatwang. My metric number 054461. So, for the part where an unincorporated association has ceased to exist, leaving surplus funds, where several persons come together to form an incorporated association, it is common for them to generate funds by subscription, fines, donation, fundraising activities, and other else. If the association is subsequently dissolved or otherwise become a defunct, the court are often called upon to determine what should happen to the association's surplus funds and other assets. We can refer to the case Re-Gillingham Bus Disaster Funds, 1958. So, this accident killed 24 Royal Marine Cadet and other person was injured. So the public raised £90,000, but only 2,500 used. So the term such worthy cause or cause in the memory of the boys who lost their life as a mayor may determine. So the questions: in which manner such surplus funds ought to be dealt with. So the court held that funds should revert to the donors or and resulting trust, and that money from unidentified donors should be paid into court rather then to the Crown, it was clear that their contribution were meant for the sister victim and not for the Crown.
Assalamualaikum and hi, my name is Amir Zafri bin Ahmad Tarmizi. My matrix number is 055824 and I will be elaborating in the case of St. Andrew's Kim Lawn Tennis Club Trust 2012. This case deals with charitable and non-charitable purposes. It concerns a dispute over beneficial ownership of land that had been occupied by the St. Andrew Lawn Tennis since 1938. The trust deed declared that the trustee held the land on the trust for the purpose of a sport ground for games for any person associated with the St. Andrew Church. The trustees of the club argued that the declaration of the trust dated 11 July 1938 was invalid and that land was held on the resulting trust for the members of the club. The court was held that the trust deed was an attempt to achieve the legally impossible, a perpetual trust for non-charitable purpose, namely to enable the member of the club to play tennis. It was clear that some of the purposes specified in the trust deed were not charitable. A gift for purposes, some of which were charitable and some of which were not, would fail. Further, it was clearly stated that the primary purpose of the trust deed was to benefit the club. If the trust deed were not to be restricted to exclusively charitable trusts for the benefit of the church, the club would be deprived of the benefit that it was intended to have and had in fact enjoyed for the past 70 odd years. In those circumstances, the trust deed was not invalidated by the Charitable Trust Validation Act 1954. The correct conclusion was that the land was held on the resulting trust for the executors of the states of a church secretary. In conclusion, as the law presently, it appears that the traditional doctrine of resulting trust remains unchanged, albeit with slight adjustment. The automatic resulting trust has been tamed to the point where it may be argued that rather than arising automatically as a result of trust failure, the court should apply the presumption to such situations with the same consequences except for the remote possibility of the rebuttal. Resulting trusts are created by operation of law when the law assumes that the transferor intended to create a trust in his own name. Then it will be up to the transferee to rebut this presumption with the evidence that a beneficial transfer was intended, with the exception of certain personal relationship where the presumption of advancements applies, reversing the outcome. That's all from us. Thank you.